Welcome to the New York City Bar Association podcast. Should lawyers and judges be required to disclose their use of AI? To many of us, the answer seems obvious as the AI wave continues to crest. Today, the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies hosts Judge Xavier Rodriguez, U.S. District Judge for the Western District of Texas, and Maura Grossman, a lawyer and scholar specializing in technology-assisted review, to give that question a closer look. With lawyers filing in court, perhaps we're leaping to conclusions that don't match our experience.
I understood the impulse of wanting to do this, but looking at the pros and the cons, it seemed to me that there were already tools to deal with this problem and the downsides were great.
But when it comes to judges, the risks may be just as high as we think.
If the judge is using it to understand the case, perhaps even to do findings of fact, I separate that from the actual conclusions of law and judicial analysis and the rendering of the opinion.
Judge Rodriguez and Professor Grossman consider many cases and court rules from the past year as we pull apart the surprising nuances of the question: should lawyers and judges be required to disclose their use of AI? Opinions expressed are those of the speakers and not necessarily of the City Bar. Here's David Zaslowsky.
Hi, my name is David Zaslowsky. I'm a member of the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies. There are a number of different subcommittees that have been created under the umbrella of the task force. I am co-chair of the task force subcommittee on the use of artificial intelligence in the judiciary. And today's podcast is hosted by that task force. The three of us that you're going to hear from today, we are all members of the task force subcommittee on the use of artificial intelligence in the judiciary. So turning now to introductions, as I said, I'm David Zaslowsky. I am a partner in the New York office of Baker and McKenzie. I practice in the area of international litigation and arbitration. I am the co-author of the international litigation column in the New York Law Journal. I'm also the editor of our firm's blockchain blog. My undergraduate degree many years ago is in computer science, but as a result of that, many of the cases that I have worked on over my career, one way or another, relate to technology issues. I'm joined today by Xavier Rodriguez, U.S. District Judge in the Western District of Texas. He was appointed in 2003. He's also an adjunct professor at the St. Mary's University School of Law. He teaches e-discovery, federal courts, employment law, and tech and law generally. There's a very broad spectrum among district court judges on the issue of the knowledge and engagement with AI, and Judge Rodriguez is certainly at the very knowledgeable part of that spectrum. And then finally, Maura Grossman is a research professor in the School of Computer Science, but she's also cross-appointed to the School of Public Health Sciences at the University of Waterloo. Professor Grossman is also an adjunct professor at the Asgood Hall Law School, that's at New York University, and she's an affiliate faculty member at the Vector Institute of Artificial Intelligence. All of that is in Ontario, Canada. In addition, Maura is principal at Maura Grossman Law, which is a technology and law consulting firm in Buffalo, New York. Recently, Maura's scholarship is focused on responsible artificial intelligence and AI as evidence, particularly on the issue of deep fakes. So with that introductions, let's jump right into the substance. There is a now infamous case in the Southern District of New York. It was in 2023, Mata versus Avianca, and two lawyers in that case were sanctioned because they wrote a brief that they used ChatGPT to draft, and unknown to them, it made up fictional cases. And there were a number of other examples of cases in which the same error was reported. And reflexive responses from a number of courts was to enter restrictions and or reporting requirements on the lawyers using generative AI in their pleadings. There are at least 30 courts that have done that. And let me start with the following question. Professor Grossman, you and Judge Paul Grimm and Dan Brown, you wrote an early piece on this topic entitled, "Is the Disclosure and Certification of the Use of Generative AI Really Necessary?" Could you explain why you thought that this was a bad idea?
Well, the funny thing was, Judicature had asked Judge Grimm and me if we would write an article, and we were in the process of searching for a topic. We'd already written a couple of pieces on artificial intelligence as evidence. Dan Brown is a colleague of mine at Waterloo, and this case had just come out into 2023, and within 3 days, the first court, Judge Brantley Starr in the Northern District of Texas, had already put out a standing order requiring disclosure of the use of Gen AI before even appearing in his court. And I remember saying to my colleagues, well, here we go. Here's a topic, because I was scratching my head. I understood the impulse of wanting to do this, but looking at the pros and the cons, it seemed to me that there were already tools to deal with this problem and the downsides were great. So what were some of those disadvantages? Well, some of these orders have been very vague and ambiguous about the technologies they include. Do they include Grammarly? I read a policy this morning that I was asked to give some feedback on, and I said, well, a calculator would fall within your definition of artificial intelligence. Do you really want people to get permission to use calculators? So there's that, and we're going to talk about that a little bit more. Some of them had been overly broad, sweeping all kinds of things into their scope that do not pose the same kinds of hallucination or inaccuracy risks that the generative AI tools do. So Grammarly, for example, doesn't pose that kind of risk. These disclosures may start to infringe on a trade work product, because normally how you go about preparing your pleadings in your case is considered work product. We thought that having this sort of mosaic of inconsistent individual standing orders was not really the best way to solve the problem. Number one, when there are already existing rules that could do it. And number two, where people have to comply in multiple jurisdictions. Now, in one, you have to do the certification. In another, there's just a disclosure. In the third, there's another requirement. We were concerned that these orders would impede innovation and chill the use of technology. And we thought that this was amazing technology for access to justice and for unrepresented parties who can't afford lawyers. That, yes, we're going to have some aches and pains and teething pains initially. But ultimately, we thought, you have Federal Rule of Civil Procedure 11 about the legitimacy of assertions and claims and statements made in court. You have 26G, which applies to disclosures and discovery. We have ethics rules about candor to the court. And our feeling is if people are going to break those rules, then having a standing order on top of it really wasn't going to make a difference. And we thought maybe this is really more of an educational issue and a notice issue. Let's get people to understand this technology and what some of its pitfalls are. And if you're going to have a rule, then at least do it at the level of the whole district. Put it out for public comment so you can learn about the unintended consequences that people haven't thought of. And that was sort of the genesis of this article, which came to us really rather quickly. And I think we were some of the first to oppose these orders.
Yeah,
David, let me squeeze in here
please.
and emphasize one thing Maura said, was that there's already pre-existing ethics obligations upon lawyers to be candid and truthful to the court. So we don't need these orders as entered by a lot of these judges. There's already a body of both ethical canons and then, if need be, 1927 statutes to take care of this. I joked around that lawyers have been hallucinating long before and so I think a lot of judges just became overly troubled by the introduction of AI, caught them unaware, and I think there was a lot of unnecessary angst in drafting these things.
Yeah, I think that's a good point. When I saw it and then saw the reaction that the two of you have already talked about, that became like the poster child for people talking about AI and lawyers. But that was not an AI issue. That was an issue of just bad lawyering. And AI was just the vehicle. So I certainly agree with what both of you have said, that the order really just seemed like a overreaction to an issue of bad lawyering rather than AI technology.
But also, I think the sanctions also were in part a result of, if they had come forward and said, oopsie, we made a mistake, but they pushed back. They gave copies of fake cases and they kept saying, well, we used this. And then in other cases, people blamed it on the paralegal and all kinds of stuff. And I think that didn't help their case particularly either. They didn't immediately say, we made a mistake. We can't find the cases either. We withdraw our brief. We'll submit a new brief tomorrow. That's not what went on here.
Right. So that was, as you said, more a early thought leadership piece on the subject. Let's move a little more current. And earlier this year, the Fifth Circuit thought about joining the chorus of courts with certification requirements, and they proposed an amendment to their own Rule 32.3, which would have introduced a requirement for attorneys to certify the extent to which they use Gen AI in the documents they submitted to the Fifth Circuit. And just let me actually quote the proposal, or part of it. Quote, additionally, counsel and unrepresented filers must further certify that no generative artificial intelligence program was used in drafting the document presented for filing, or to the extent such a program was used, all generated text, including all citations and legal analysis, has been reviewed for accuracy and approved by a human, close quote. And the two of you collaborated on a response to this proposed rule change. Judge Rodriguez, can you tell us a little more about that, what your response was?
Yeah. So for all the reasons Maura just gave about why these district court orders were problematic and unnecessary, I felt the same. Frankly, I brought in Maura as my friend to support me in this endeavor, using her name and influence to see if I could get the Fifth Circuit to delay anything here. So one difference between the appellate courts and the district courts, it's already bad enough to do an order and it would be prohibiting you from using Grammarly and even AI tools that would create timelines. I think all that's unhelpful. But one thing I've not seen anybody giving real thought to are, as clients now are using AI tools for business purposes, that's all going to make its way into what's going to be tendered into evidence or in the record in the trial court. And then when the record goes up on appeal, how is an appellate counsel going to be able to certify that no Gen AI was used? That appellate counsel doesn't know whether AI was used in any of the underlying exhibits and material down below. They're not giving adequate attention to what's already out there in the world. People are trying to, I believe, put the cat back in the bag, and the cat is out and it's not going to go back in. And so we'll see how successful in the long run we are about getting these courts of appeals to delay orders. The other problem I had with this order too was it shouldn't be tech specific. It ought to be tech agnostic, not just AI. If you're going to say, hey, you're reminded, counsel and unrepresented parties, you're reminded of your obligation to ensure the accuracy of all filings, I wouldn't have a problem with that, but that's not what they're doing.
Yeah, I'm old enough to remember when Lexus was that old red terminal and it was new technology and it was printed on that thermal paper, and no one at the time had to remind us, you still have the ethical obligations. You got to cite the cases, even though it was at that time this newfangled technology. Can I ask you, what did the Fifth Circuit do? And also, do you know whether the comments, how they weighed more, plus, minus? If I don't know if you know that one way or the other.
I did glance at the comments that were submitted. They were all over the board. Some people thought AI needs to be killed because it would be the death of all lawyers. That there were comments to that effect. There were comments along the lines of Maura and my suggestion. And so they were all over the board. Ultimately, this has just been no decision was made one way or the other. It was basically just shelved with no decision made.
I mean, effectively, no decision means status quo, and status quo means no certification requirements. So I guess you guys were successful on that one, or at least your position is the one that exists today in the Fifth Circuit. When I think about this issue as a practicing lawyer, and a practicing lawyer in a big law firm, you have all kinds of subject matter experts in a law firm. You have lawyers with significant amounts of experience. And one of the benefits of being in a law firm is you can just walk down the hall and engage these colleagues in conversations and get ideas for a brief. And you can have colleagues review your brief, and that they may suggest to you to include cases that you didn't know about or you didn't think about. And since I don't have to disclose those interactions that I have with my colleagues, why should I have to disclose using generative AI for essentially the same purpose? I mean, that's the way I've looked at it as a practicing lawyer in a law firm. Is that a fair analogy? Does that resonate with you guys at all?
I have a little bit of trouble with the analogy because presumably your colleague doesn't hallucinate between 17 and 33% of the time.
I would hope.
And if they do, well, then maybe there's some issues there. But they wouldn't make up a case. They may say, I remember a case from the Southern District of Texas. Maybe it was this guy Rodriguez. I'm not sure. I think he said X. And you would go look it up and you would read the case. And maybe he said X and maybe he said not X. But you wouldn't just take it on face value and cite it.
But Maura, isn't that exactly the point? That if I'm using AI properly, I'm not just going to take the AI. Just like if my partner says, yeah, I remember Judge Rodriguez had this opinion back in 2007 or something, the burden is on me. The onus is on me to go make sure that the case says what my partner remembered. And likewise, the burden should be on me if an AI suggests some case that Judge Rodriguez wrote.
Right, but your AI didn't go to law school and it doesn't have legal judgment.
Yeah, that's where I'm headed, David. I have a little problem with your analogy too, right? You're walking down the hall with a coffee cup in hand, assumes that you've talked to someone who has learned opinions, who's got a JD, but the AI tool is merely doing a predictive analysis. And so it's not doing the same thing as you conversing with your colleagues down the hall. So it sounds like a good analogy, but I'm not sure it's on spot.
The New York City Bar Association is a dynamic community of over 23,000 legal practitioners. Members shape the future of the legal profession, serve the public, and gain an edge in their careers. To learn more about becoming a member of the City Bar or to join today, visit nycbar.org/join. Save 20% on semi-annual dues when you join. Call Customer Relations at 212-382-6663 and use code POD24.
Let's move on to another example of what happened this year, just like the idea in the Fifth Circuit. And earlier this year in New York, there was a proposed amendment to the CPLR that would have added a new provision. It would have been CPLR 2107. It would have required the disclosure of the use of generative AI in civil lawsuits. And I want to read out the definition used in that proposed statute. Quote, for the purposes of this section, generative artificial intelligence shall mean the use of machine learning technology, software, automation, and algorithms to perform tasks to make rules and or predictions based on the existing data sets and instructions, including but not limited to. And then it went on to have 5 additional subsections. And this was drafted so broadly, and it touches on something both of you mentioned earlier, but it was so broad that it would have covered spell check software. And since that is used on a daily basis, the statute essentially would have been triggered for every filing, virtually every filing made in the court. So I'm interested in your views on that, but also, do you have suggestions for legislatures on how to avoid this problem? Or maybe this is just further evidence of why they should keep their hands off? Either one.
So I guess I was kind of surprised. I'm coming from Texas, right? And so the Texas legislature normally doesn't delve into issues of rules of civil procedure like apparently your New York legislature does. And so when it comes to issues like this about disclosures, I really do think that the courts need to be driving whatever we do as opposed to the legislatures, because oftentimes they draft legislation without fully understanding just what's going to be the impact on the ground. That's observation number one. Observation number two is there's a fine line for legislative activity here in this AI. We've got to be cognizant of the legitimate concerns associated with artificial intelligence tool, maybe privacy implications, consumer rights. At the same time, I don't think we want to be so stifling with any kind of legislative enactments that we're actually going to hamper the development of AI tools for some of its good uses. At this point, I think I'm seeing, and Texas included, a lot of very broad statutory bills being considered that I think they're biting off more that they can chew. They ought to be tackling the one or two issues they think that they need to tackle. If the concern is consumer privacy, then let's tackle that in a surgical fashion. If the concern is deep fakes and fabricated digital pornography, then let's use a surgical scalpel to tackle that. But I think they're trying to be over-encompassing.
No, I agree with you. And part of this is a function of you really need to involve tech people and you need to put these things out for public comment. I think our subcommittee unilaterally, full consensus, rejected this particular. I mean, most of us immediately saw the problems, and obviously whoever drafted this did not speak with any lawyers who actually use these tools on any regular basis. It is very tricky, the regulation area. What sort of surprised me was the quickness of the response to this particular fake case issue, which really is a blip on the radar screen, and the dismissal of the far larger problem of deepfakes. And so it's like rearranging the deck chairs on the Titanic or something like that when a tsunami is coming, that people got obsessed with this issue. And understandably, I can understand why the judges did, because nobody wanted to be the first judge that cited a fake case. That would be just horrific. But I'm not sure it was the best idea for the legislature at this early date. There's this impulse to act immediately, but sometimes you need to pull back a little bit and assess the risk. And as Judge Rodriguez said, attack things in a more surgical fashion. There are clear issues we can address, like bias, use of these tools in HR, sort of functions, and other areas where the problems are clear and immediate. This problem is just not, it's just not of the same level.
I was really amazed by likewise with Maura's observation, how some judges, and the ones in particular who had bad filings, how they reacted. It's like, oh my goodness, the sanctity of the temple has been violated. I don't know how many times I get arguments, briefs, where cases are raised. They're legitimate cases, but they don't stand anything for the proposition that people are claiming that they stand for. They've misread the case or don't understand the case. I mean, the overreaction to the AI hallucinations was really kind of astounding to me.
Yeah.
One of the points that Professor Grossman just made, I found really interesting, and Judge Rodriguez, maybe you could comment as a judge, is maybe part of it was nobody wanted to be the first judge who actually had one of these cases make it into their decisions. And so that actually could explain why you have this overreaction of judges either barring it, just saying you can't use it, because if you can't use it, then the judges don't have to be worried about there being the first one, or the certification requirements. That was a very interesting, I found that to be a very interesting observation. And maybe that's part of the explanation of the overreaction. Interesting.
Could be.
So let's change the subject a little bit. Right, we've been talking until now about lawyers using generative AI. Let's turn now to judges using generative AI. And let me start with this general question for either of you. Should there be requirements that judges disclose their use of generative AI?
So go ahead, Mark.
I was going to say, it depends what they're using it for. If they're using it, they've written something and they want to make it a little more terse or clean up the grammar or something like that. No, I don't think there's a need for that. If they're relying on it for the definition of a term or some aspect of the decision, yes, I think that then there's the risk that they're going outside the record that was not presented by the parties. The parties didn't have an opportunity to argue as to that particular evidence. So I think it's very context specific. There are plenty of uses that I think nobody would have a problem if a judge wanted to summarize certain things that were very lengthy, like certain transcripts they'd already read, but they wanted a little summary to jog their memory. Or if they want a chronology, they're familiar with all the events, but they want to create a chronology of those events that they can have on the bench during the trial. I don't think any of those kinds of uses pose the problem. It's when the use is replacing what we would normally consider part of the judicial function, the core judicial function, that I think the issue becomes much trickier.
Yeah. So judge use of AI. First of all, we don't have anything to say exactly what tools judges are using out there from some kind of an official basis. The administrative office of the courts and the federal system have been fairly silent and not providing much guidance other than be careful. And likewise, state courts are doing the same thing. Delaware, most recently, their Supreme Court issued some vague guidance that talked about tools, but then didn't specify what tools they may or may not allow to be used. That's going to be a work in progress. So we don't know what people are using out there. I'll suggest to you, though, that judges are using it because earlier this year, back in February or so, I spoke to about 200 state district judges in Texas. And started off my presentation with, well, how many of you have already used an AI tool? I'm speaking to a group of 50 plus years old, generally white males in the audience. And I was expecting just a handful of hands to go up. To my amazement, about 3/4 of the hands went up. I was kind of shocked by that. I was so shocked, I did not dare in a public setting ask anybody, how are you using these AI tools, for fear what the answer might come out. So we know judges are using it. They're probably using a product that they got on their own that wasn't court issued. So I'm a little concerned about that. I'm not sure they're using any kind of enterprise AI tools or any AI legal curated kind of tools. I think they're basically using ChatGPT and free versions, at least back in January or February. Hopefully after my speech, I have sort of encouraged them not to do that. So when they decide to use an AI tool, and let's say it's a paid proprietary version that's somewhat more accurate than the freebies that are out there for legal purposes, Again, it all depends on how they're using it, right? If they're just using it to create timelines, so when they're having a hearing, they have a better sense of going into the hearing and understanding of what the case is about. I don't think they should be able or have to disclose anything like that. If they are taking an AI tool and actually sort of replicating, so some courts don't have court reporters, they have only audio tools. And so then that needs to be transcribed. But they're using an AI tool to do their own recording of it, an unofficial recording, and then summarizing that. I don't necessarily have a problem, and I don't think they ought to disclose or should be required to disclose the fact that's sort of their shorthand notes for the hearing. But now, if they're going to start actually generating an opinion, I think we're getting into more problematic areas. There's about 2 or 3 judges around the world who have disclosed that they have used AI in their drafting of the opinion. And I'm not sure any of the AI tools out there, even the very best, are able at this point to actually create a final product. They're tools, and they should always be used as a tool. I don't think they're ready for prime time or as is publication by any stretch of the imagination.
Or even for the decision making. There have been a couple of courts that have admitted I've asked the actual legal question in front of me to the chat GPT and to get an answer. And even that, I think, is probably crossing the line.
But you know, that it can be a nice first tool. Right now, I'm playing, and so this is not being used for official work, but I'm playing around with products and seeing what they could potentially do as a first draft. And as a very preliminary, rough draft, I could see some savings for judges in terms of time and resources. But again, from what my experience is showing me right now, as I'm using these various tools, the best ones are producing a very rudimentary draft, but nevertheless, it's a good, decent draft with pointers to the underlying record that a judge could use to further expand upon his or her writings. And so it's already showing promise.
But they're not writing the decision for you.
I'm with you. It's still a draft.
Let's drill down on that a little more, though. Right. Judge Rodriguez, you're a federal district court judge in the United States, and you have clerks and you have other resources that help you perform your job. But there are also courts in the United States, especially state courts, where judges are just overwhelmed. I mean, their dockets are just overwhelming. And perhaps it's not ready for prime time right now. Progress is being made exponentially. Who knows when it would cross that threshold where the two of you would think it's ready for prime time. But assume a situation, and I think it's probably not that far off, and maybe it's even happened already, where you have a judge who really is overwhelmed, doesn't have the resources, and they just upload the briefing on a motion to dismiss. They upload the briefing into some AI platform, and they ask the AI system to generate a draft opinion, and they read it, and they think, this is good enough. And I don't have time to look at all of those cases. And this seems like justice. Maura, I see on the video, you're already shaking your head no, and I understand that. So 2-part question. I think, Maura, I see on the video, you're shaking your head. Are you okay with that? And then, well, I guess part 2 is, if you're not okay with it, does it have to be disclosed? But if we assume that there are judges who do it or will soon be doing it, should they have to disclose it?
Yeah, so I'm not okay with that for a number of reasons, unless so I did an online AI dispute resolution, and I'll tell you that story. But if you know it and you agree to it, that's a whole, and because your claim is worth $13 and you're not going to go to court on a $13 claim, but you're pissed because you got broken earrings in the mail, then maybe that's fine. So that's what I did. I had spent $13 or so on a pair of earrings, and one of the posts was bent beyond repair. And I contacted the vendor, who essentially said he was not an English speaker, so there were some language issues, but essentially said if you weren't such a moron, you could bend this and fix it. And I asked my husband, who's much more mechanical than me, and he said if I touch this thing with a pair of pliers, it's game over. So I said, I really like these earrings. Just send me one. You don't have to send me another pair. Just send me the left one, because the right one's fine. And the guy said, no, you have to return the 2 earrings all the way to China, but before I'll even discuss this with you. So I look into that, and to return them costs about $30. So my husband is saying, just buy another pair of earrings, please. I'll buy them. And I'm like, no, I'm arbitrating this. I'm taking this to court. So they had an online dispute thing. So I'm typing away, and I take pictures of the earrings, and I send screenshots of the correspondence and everything. And I said, look, I'm being reasonable. I just want him to send me one earrings. And so it was decided online by an AI, and I got $1.38 back because I did get some value from the one earring, apparently. So I do sometimes wear the one earring because I have to get some value from using it. And they weren't going to pay me back for the shipping costs or anything like that, but they figured I was out about $1.38 of my $13. But it was quick, and I didn't have to go out of the house, and it was resolved in 15 minutes. And maybe for some things that's perfectly fine. But for most things where people go to court, I don't think so. And the other problem is there's a thing called anchoring in psychology. So once that AI gives you what it thinks is the right answer, the court, there's a confirmation bias. Unless the court really knows the law in that area, they're unlikely to question it. And so you're delegating the whole responsibility to an AI. Now, if you're in British Columbia and you agree to go into the AI court and there is an appeal mechanism to a human, that's a different story. Then I don't have a problem if you have a low value matter. But do I want my employment matter or my discrimination matter or my child custody matter or my criminal matter decided this way because the judge is busy? No, not at all.
So a few points there. So the judicial canons govern this a little bit. Nothing's, of course, came out AI specific, but a judge is supposed to uphold the integrity and independence of the judiciary. A judge is supposed to avoid impropriety, and a judge is supposed to perform the duties of the office fairly, impartially, and diligently. So if a judge now then is just using AI to do his or her work without any kind of review, that may violate one or more of those canons, because basically the judge has just sort of made the AI the judge and just adhering his or her name to it. And so that's problematic. But like in all things, right, it's all a matter of cost benefit, right? And especially for the state court judges, as you mentioned, David, they just have a lot less resources. So how long is a litigant supposed to wait for their justice when some of these AI tools, again, they're tools, but if we can give these tools and roll them out to the judiciary, explain how they are to be used, the limitations of their use, what needs to be done in terms still of prompt engineering and reemphasizing, we have to check the accuracy of the results. If it could help us expedite the judicial process, I'm all for it.
Right. And what I'm suggesting is not far-fetched. I mean, there was reporting in the news that there was a judge in Colombia who had to decide an issue of whether health care for an autistic child was covered under an insurance policy. And it was reported that he put the question into Chat GPT, and that was his decision. And another reported case in the UK where a Court of Appeal judge, he said he admitted he used, and quote, a jolly useful Chat GPT. And yeah, he said it gave him a paragraph and he already knew what the law was. And so it was okay, but he found it useful. But that goes to Maura's point. if you anchor, uh, okay, or recency bias, this is what the Chat GPT or Claude says, and say, well, yeah, I think that's right, but maybe that's because of the anchor, or that's because of the recency bias. And I get back to part of the question I asked before. If it's going to be used, should there be a requirement that it be disclosed?
Yeah. So again, and I want to bifurcate the use, right? So the judge is using it to understand the case, perhaps even to do findings of fact. I separate that from the actual conclusions of law and judicial analysis and the rendering of the opinion. I think for the first part, there's a lot of helpful aspects of AI. But if you're going to start venturing into the second part, actually to apply what AI thinks is the law, I think that's very problematic. I think an American jurist should disclose if that's what they're doing. And I hate to say that, almost providing, because it's almost sounding like providing an advisory opinion. But if I did something like that, which I wouldn't, but if I did, I have to almost issue that as a draft and invite the parties to submit arguments in light of that draft. Because I'm very leery at this stage of the game. It's not ready for prime time for that kind of use.
I don't think we disagree here.
That's an
all,
interesting
really.
idea,
Yeah.
though, of doing it by way of a draft opinion, because if that is a vehicle for saving resources or helping judges who with limited resources, and in a way that's a bit of a safety net, right? You use the Gen AI to generate the opinion or to help the judge draft the opinion. And then your backstop is that, your safety net is that you're not issuing it as your final opinion. And then you're allowing the parties to take aim at something that's on paper. That's an interesting idea. Again, for courts that are resource challenged. I like that idea. Interesting. Maybe that's a way to at least get your toe in the water, maybe more than your toe. You mentioned before the Delaware Supreme Court, right? And they issued an order, and it was addressed to the judicial officers and the court personnel in Delaware. And it allowed the use of what they called approved Gen AI. And of course, so far, nothing has been approved, so it doesn't really have any meaning yet. But apropos what we were just talking about, it also said that, I'm just going to quote, authorized users may not delegate their decision-making function to approved Gen AI, close quote. So it looks like the Delaware Supreme Court was thinking about what we've just been talking about, right? So it's the delegating where they draw the line. So is that you think a good distinction that they made, or a good point that they made, separate from the use of what will become approved Gen AI?
No, I tend to agree with that non-delegation. I'm still sort of waiting on what the rest of the order meant, because we don't have any tools that they've actually authorized.
Right. Yeah. So I mean, any thoughts on why they did what they did? I mean, in terms of issuing an order that really has a big hole in the middle of it. I mean, I don't know if either of you have any insight into what's behind it, but it does seem a little strange.
Yeah, I have no insight, but I mean, I'm just guessing here at this point. Do they have in the wings right now a bunch of tools that they've already vetted, that they're just finishing off the vetting process that they plan to be rolling out? If so, why didn't you do it all at the same time? I don't know. I'm guessing.
Although I've seen others that are like this. I've been consulting on one in another state that also has a hole for what the approved tools are. So I think some of these processes are going on simultaneously. They may be vetting one group off to the left side, vetting tools, and a legal regulatory sort of compliance group on the right side coming up with the policies and the procedures and stuff like that. And they just may have been out of sync.
Along the lines of what we've been talking about for the past little while, and actual use cases for judges. Kevin Newsom is an 11th Circuit judge, and he made news earlier this year with his opinion in a case called Snell versus United Specialty Insurance. The site, if anyone wants to look it up, is 102 F 4th 1208. And that case was a lawsuit that was brought by a landscaper who wanted coverage under an insurance policy in connection with an accident that occurred while this landscaper was installing a ground level trampoline. The insurance company declined coverage, and their position was that the accident did not arise under, quote, landscaping, and that's what was covered under the policy. Now, ultimately, the court decided the issue based on a specific provision of state law that says the insurance applications are part of the policy, and so that was the basis for the ultimate decision. But before that outcome was reached, Judge Newsom believed that there was going to be a need to determine the meaning of the word landscape. Now, again, that was not ultimately necessary for the court's ruling. Judge Newsom then wrote a concurring opinion that described his Gen AI journey in the case. And what he wrote at the very beginning, of setting the stage, what was very interesting. So let me just read it. Right? Quote, "Here's the proposal, which I suspect many will reflexively condemn as heresy, but which I promise to unpack if given the chance. Those like me who believe that, quote, ordinary meaning, close quote, is the foundational rule for the evaluation of legal text should consider whether and how AI-powered large language models like ChatGPT, Gemini, Claude might inform the interpretive analysis. There, having thought the unthinkable, I've said the unsayable. Now let me explain myself." Close quote. So that's how that was the beginning of his opinion. And then he went through the journey that he followed. Now, in my view, using AI to help determine ordinary meaning seems like a pretty modest step. But from what I just read, Judge Newsom didn't. Clearly, he didn't think it was just modest. He said heresy is the word that he used. Judge Rodriguez, what are your thoughts on, number one, what Judge Newsom did, and also just the context that he laid for committing this heresy, to use his word?
So I applaud him. I think it was great that he waded into this, and so good for him. I'll note that I think
Right.
it was a concurring
Yes,
opinion.
absolutely. It was concurring
because
opinion.
I don't think, if he wrote this as an opinion, I'm not sure he would have gotten another colleague to join. So it was a concurring. But so his use of AI to come up with ordinary meaning, a lot of this sort of depends on, okay, how was whatever AI tool he used, and I'm not sure he disclosed it, but maybe my memory doesn't serve me well here. Did he, Maura?
Yes.
I think so. I think he did.
So if he disclosed the tool, how was the tool built? And so is this an international body of work? And so when we're talking about the ordinary meaning of a term in a United States insurance policy, is this going to be skewed in some way? I'm a little concerned by that. I am a little concerned that, is this going outside the record? In his case, that may or may not be the case. But I think judges need to always be cognizant that the facts are developed by the lawyers. And I, as a judge, I don't feel compelled to be bound by whatever law the parties submit to me. If they're wrong in the law, I'm not going to repeat the error. But the facts, I feel that I'm bound by what's tendered to me by the parties. And so I'd be concerned about that.
So I've had mixed feelings about this over time. When I first read it, I said, oh, that doesn't strike me as all that like off base, because you could look in a dictionary. Basically these tools are trained on the internet. And so that might give you an idea of at least what the average internet user, who's probably Western and English speaking and some other stuff, but in any event. So my initial gut reaction was, that's not really a problem. And as I talked to more people about it and thought about it more, I got a little more concerned. And if you look at Judge Newsom's second opinion, I think it's the De Leon opinion where he also again used generative AI. He asks the same question multiple different ways to multiple different tools, and he gets multiple different answers. Now, yes, you might, if you consulted 4 dictionaries, get a slightly different interpretation, but it's probably not going to be material. That's very problematic, I think, the lack of reliability and the potential bias. So what if instead of asking about the term landscaping, he's asking about a slang term and whether something was defamatory or not? Is this an insult or not? Well, it may depend entirely who you ask. And that may vary on cultural or racial or age or religious or other demographic variables. And I could see that being very problematic. So maybe it's okay, maybe it's not okay. I think as one point of information to consult, I don't think as the final dispositive, this is the common use, that we're there yet. But I think it's one point of information. But I agree with Judge Rodriguez. I'd probably want to allow the parties some opportunity to argue whether it was correct or not before I put it in a final opinion.
Let me push back a little bit, right? So you gave the example more of slang and what does it mean, and that can have a cultural difference or a regional difference. But if you are a judge having to make that decision, right, how do you, especially let's say something slang, how do you get those regional differences or those cultural differences, right? You would need, yeah, go ahead. Right.
Experts is one, or people who are from that culture or group. It's very different. I have lots of gay friends who call themselves queer all the time, and I'm very careful about using that word. It's very different when somebody uses a word to refer to themselves versus mine using the word may have a very different context and meaning for that and experience for somebody else. So I think you have to be very careful about just asking a chatbot, because that is not going to be a representative sample of maybe people from that particular group or culture who may in fact find it very hurtful and harmful as a term, whereas the majority doesn't, or vice versa. So I think there are contexts where it really could be.
Yeah, that's a good point. But
problematic.
In Judge Newsom's second opinion, as you pointed out, he did lay out the different prompts that were submitted to the different platforms, and it's the well-known ones, that ChatGPT, Gemini, Claude. And what was interesting is while they did not all give the exact same answer, and you would expect that, right, Maura? I mean, you know the technology of AI better than I do. You wouldn't expect them. You'd be surprised, actually, if they all gave the same answer. But didn't it sort of coalesce around a definition that seemed to be, you could say this is in general what it means, even though not every answer was exactly the same? I think that's the point he was making, is that he was surprised that he got different answers for the same prompt. And he was surprised when he asked the same platform, the same prompt, and it gave a different answer. And so originally he said, well, this can't be right if I get a different answer all the time. But then when he looked at the whole, and he said, this is my recollection, and it sort of coalesced around something that could be right. At the end of the day, he said, maybe this is okay.
Coalesced around something that could be right is the operative. That for me
that's my poor recapitulation of what he said.
Good enough for government work doesn't work for you?
Yeah.
Look, I think there's going to be experimenting that's going to be done. There's going to be trial and error. I agree with Judge Rodriguez. I commend him for experimenting and with public and for getting us to have the discussion. I'm somewhat ambivalent about it. I don't think I have come to a final decision because we don't always know what it reflects.
It really sort of depends on what type of case, right? So for
Right.
what he was doing, maybe the differences are not so nuanced and concerning that it was okay in that context, but used in a different context. We're going to start doing this for claim construction, for example. I mean, nuances in intellectual property cases get exemplified much greater. And so I think it depends on just what the case is and how you're using it and what does it come up with and do the differences or how subtle are they and does that really matter?
Right. But I remember a case where a court got very angry at an expert that had cited an average fee, lawyer's
Oh,
fee in
yeah.
a particular area. And that didn't strike me as such again, a horrible
So,
use,
you know that
but
I remember, if I'm remembering this, and this is the same thing that you're talking about, somehow the AI tool miscalculated what the attorney's fees were going to be. But when you read that case and you went in deeper, everybody just highlighted, oh, see, it erred. But what it aired by like $25. And so
yeah.
like what? We're going to bring in an expert witness here to calculate the present value and blah, blah, blah at whatever cost and bring him to court to prove this all up when it turned out to be a $25 error. Uh,
No, I agree with you. I remember thinking, I wonder why this judge is so angry that this expert did that. It seemed to me again like a not the correct answer. Okay, rubber stamp. The computer said this is what the fee should be, but one piece of useful information. I didn't have a problem with that, but he didn't quite sanction, but he chastised the attorney for even making the argument, and that surprised me a little.
People are expecting too much of these AI tools at the moment. They're expecting perfection, and none of us are perfect, and these tools aren't perfect. And so they're become, I don't know, Maura's rightfully concerned. We don't want to be just good enough for government work and shove it all aside because sometimes things are really important, but we shouldn't be expecting perfection. And
Well,
we
you
got
made
to
the point
verify
earlier
results.
that, in your view, lawyers have been hallucinating for years. So that's a fair point. Let's end with this. Do you think more judges should be encouraged to do what Judge Newsom did? And also, what he did is he fully disclosed what his searches were. And that goes to the other point we've been talking about in terms of disclosure. But should more judges be encouraged to do that and share that?
I think we need in the judiciary, both in the federal system and the state systems, I think we need to be doing a much better job of educating judges, not only in AI, but technology in general. We do a woefully inadequate job of that. It's all the more important as life goes on. AI is, I think, the big wake up call. And so I think before we start encouraging judges to do this, we ought to be upping our game on the education process. And then as part of the education process, we educate judges about the pros, cons, and limitations of this technology. And then we set us loose.
Yeah, I don't know that I would encourage that particular use case, but I think there are several courts that have set up safe sandboxes. So these are closed systems. It's not GPT going out to the public, but it's within the enterprise where judges can play with these tools. And I think that's critically important that they start educating themselves on what they can do and what they can't do, what are safe uses, and not relying on other people telling them, but actually getting some personal experience. And I really applaud any of the jurisdictions that have created for judges. Pennsylvania is one of them. Created sandboxes. They have universities with computer science departments that have made resources available for judges to be able to experiment, and they really enjoy it. And I think it's very eye-opening for them, and it's important because they're gonna have cases that involve all kinds of AI, and this will also give them some comfort and experience interacting with it. So I think that's a good thing.
So thanks for joining us today. We look forward to recording other podcasts covering issues related to the use of artificial intelligence in the judiciary. We look forward to your joining us on those additional podcasts, as well as on podcasts and CLE programs from other subcommittees on the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoyed this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. And don't miss Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced and edited by Eli Cohen.